What are examples of confidential information? Have you ever wondered what types of information are kept under wraps in the legal world? Understanding what constitutes confidential information is essential, especially for those in legal internships and clerkships. Let's break it down. Confidential information refers to data that is not publicly available and is protected from unauthorized access. In the context of legal internships, maintaining confidentiality is a fundamental responsibility. First, let's look at basic personal details. This includes your name, date of birth, age, sex, and address. These identifiers are considered confidential and should be handled with care. Current contact details like phone numbers and email addresses also fall under this category. Next, we have financial information. Bank information, including account numbers and transaction records, is highly confidential. This type of data can be sensitive and must be protected at all costs. Medical history is another critical area. Any medical information, including diagnoses, treatments, and medical records, is considered confidential. This information is private and should only be shared with authorized individuals. Let's not forget about personal care issues. Details about an individual's health or personal care needs are also confidential. This includes any information related to mental health or personal support services. In legal contexts, confidential information can extend to specific examples. Service records and file progress notes are detailed records of services provided or progress made in a case. These documents must remain confidential to protect the parties involved. Personal goals and assessments related to an individual's development are also confidential. This information can provide insight into a person's aspirations and should be kept private. Guardianship orders are another example. These legal documents establish guardianship over an individual or their property and must be treated with the utmost confidentiality. Incoming or outgoing personal correspondence, such as letters and emails, is also confidential. This includes any communication that is personal in nature and not meant for public disclosure. In legal internships, maintaining confidentiality is critical. Interns should never disclose any confidential information they encounter during their work. For instance, if an intern is working on a case involving sensitive client information, they must ensure that this information is not shared with unauthorized parties. However, there are exceptions. Confidential information may need to be disclosed in certain situations. If there is a risk to someone's health or safety, sharing confidential information may be necessary to prevent harm. Additionally, legal requirements can mandate the disclosure of confidential information, such as through a subpoena. Lastly, if a client gives consent, confidential information can be shared with specific parties. Understanding these concepts is essential for maintaining ethical standards and legal compliance in legal internships and clerkships. By being aware of what constitutes confidential information, interns can better navigate their responsibilities and protect the interests of their clients.